Okay, welcome everybody to our June meeting of the HB 4086 Jurisdiction Advisory Committee. As y'all know, I'm Leslie Ann Hay, and Sylvia DePorto is here joining me, as well as your co-facilitators. As folks are just trickling in, just wanted to pose a question out there. It feels like we're turning the page into summer. There's graduations, there's end of school, there's all kinds of turning of the page. Go ahead and pop into the chat. Just any thoughts you have about exciting plans for the summer. You take a trip anywhere, you got family visiting, anything like that that you're looking forward to. I know I'm looking forward to some family coming in from Germany to town this next month, and get to see my new grandniece. So excited about that. And yeah, go ahead and put your name and role as well in there. So just I don't think we have anybody new at this point, but in case somebody hasn't been here for a while, they can recall who all's part of our group here. All right. So with that, I think we'll go ahead and get started because we have a pretty full agenda this afternoon. We are going to, let me minimize this. We are going to, this is our, let's see, third to last meeting of the committee. We'll meet again in July and in August. And we are really kind of turning the corner here. We have one last topic area that we want to really dive into with all of you that we haven't had a chance to yet, which is our child abuse discussion. And so we're going to spend a portion of our time today examining that issue. We had an opportunity to have some conversations with the other complex sexual behavior committee as well around that, to sort of align with what they've been discovering around that. So I think we'll have some good dialogue there. And then we really want to, we've been busy writing up the report draft itself since our last meeting. We had lots of feedback from all of you that it was really important for you to see the recommendations in context and have an opportunity to be able to weigh in with your validation of the recommendations in that manner. And so we're going to describe how we have organized the study report itself, how it maps to our work, and the fact that tomorrow, as soon as tomorrow, you're going to be receiving the first half of the draft report. And so we want to orient you to kind of the layout of that report. And we've also developed a validation process that you'll be able to participate in that doesn't require you to attend a meeting per se to be able to weigh in on content of the report. So we'll walk through that and describe how that's going to work over the coming weeks. And then we'll cover some next steps and wrap up by 4 o'clock this afternoon. We will get a break in there as well, about 2:50 or so. Any questions or comments about the agenda? Or anything you wanted to add, Sylvia, at all?
No.
All right. And as always, we want to guide our dialogue today with our community agreements. Really want to remind folks to bring your curiosity and reflections, vulnerability, skills, courage, and authenticity to the work that we'll be moving through today. We want to make sure that we keep ourselves and each other focused on our mission in general and on specific points in the moment of our discussions. open ourselves to each other's perspectives, experiences, and suggestions, and really stay oriented towards solutions that move us toward our goal. And then finally, it's so important that we're seeking out and engaging and respecting all voices of those impacted by this work that we're involved with this afternoon. So, and so with that, I want to go ahead and move into this next kind of substantive topic that we're going to be talking about this afternoon. And we're going to kind of lay out some of the assumptions around the child on child, minor on minor abuse topic that we had as part of our scope of work. Remind ourselves of kind of the key issues that have arisen around that topic. Take a look at some data, and then really have an open discussion guided by some key questions. And I'm going to turn it over to Sylvia to start us off.
All right, thank you, Leslie Ann. Welcome, everybody. So we're going to go through some information around child-to-child abuse, but we're going to look at what basically what our current assumptions are and around this issue of child-on-child abuse. So first of all, we know that there's some basic assumptions that we are responding to allegations of either sexual abuse or physical abuse from one child to another. Typically, in child-on-child abuse issues, there is a greater than a 4-year age difference, both chronologically and developmentally. So the developmental age of the child as a perpetrator would be considered in this process. And then that age difference is considered between both of those child, the initializing child and the impacted child. And then it also, our assumption would be that the investigation process would be including an assessment of family members, anybody in a parental role in the process, and looking at their role in that process. Did they know about it? Did they fail to protect the child? Was there a lack of supervision that was going on? So the investigation will reveal that, but that's just one of the assumptions we make as we're thinking about child-on-child abuse. Now, the system response to child-on-child allegations of abuse is very age-specific. What we learned in Oregon, generally, this is generally speaking, it's not 100%, but generally speaking, ODHS addresses child initiators under the age of 12 and their families. So if the child being alleged a perpetrator of sexual abuse or physical abuse, but our focus is really sexual abuse, is under the age of 12 or under, then ODHS takes that. And then if it's 13 and over, then we see juvenile justice having a role in addressing it as well, and addressing their families as well. I see Sarah's hand.
Yeah, I just wanted to ask a clarifying, maybe two questions. When you talk about these ODHS addressing under 12 and juvenile justice over 13 and older, is that what you are saying you would think you would find, or did you hear that somewhere?
I think that's what we kind of walked away with our conversation, our conversations about this issue, both with yourself and the Complex Sexual Behavior Committee. So if that's not true.
Yeah, so at screening, we don't have an age cutoff because statute does not specify that alleged perpetrators of child abuse have to be a certain age. We don't base it on age, and we don't base it on if they're 12 and under or if they're 13 and over. If we have some other guidance, so the guidance that we go by because we do try to limit how much we're making allegations against children, even though statute technically would require us to assign regardless. We have some guidance for the hotline around under what circumstances they would assign for sexual abuse or physical abuse, and never is age one of those pieces of the guidance. It's things like learning as much as you can from the reporter about what they understand to have happened, to understand whether or not, if it's sex abuse allegation, whether or not force, coercion, trickery, violence, things like that were part of the equation. Because of course we know that there are some youth of, who might be less than 3 years, 4 years in age, who consent to engage in sexual activity. And so we really want to understand, when is it consensual versus when is it more of a trick or a force or something like that. But there's no age limit. So we assign reports when the child initiators are 13 years and older, just probably even more than we do for children who are under 12. It's when the children get younger and younger that we ethically really struggle with this statutory requirement that we assign everything that meets criteria of an allegation, because sometimes children can be as young as 5 and are using force to perpetuate some sort of sexual activity on another child. So as they get younger, that criteria that I just mentioned really has to be in existence for us to even consider assigning it. As they're older, that criteria has to be there, but I guess it is just, I'm not sure if I'm really being clear, but the age isn't a part of it.
So we're gonna, go ahead. I was just gonna say, we're gonna go through that, the clarity on the Oregon. I think we were just, based on our discussion, it felt like you're really trying not to label younger children as perpetrators, and that for the older children, generally there is an involvement of juvenile justice if appropriate, if and when appropriate. So I don't know, Liz.
But I was going to say, I see what you're saying, Sarah, that in this context and sort of the general assumptions about this, all of these right now are screened from, 0 to 17 years old, right? And assigned, if appropriate, for investigation. I think what we're trying to say here, and it maybe isn't worded quite right, is that there is this extra consideration for how that investigation process and what other factors need to be taken into account when you have a child under the age of 13, because typically you don't have a juvenile justice system applying, nor is it even appropriate to apply to those kids, right? Whereas some intervention, some treatment, some kind of response can come from juvenile justice for those who are involved in this behavior and over the age of 13. Correct? So it's not like they're doing the investigation or making a disposition, but there's a response pathway, at least to some degree. Would you say that's accurate in Oregon? Like, wouldn't you bring in juvenile justice to an MDT, for example, for a sexual abuse case that's being investigated for a 13-plus-year-old?
I can't speak to, because I'm not aware of when juvenile justice would be brought into an MDT. My understanding is
probably through law enforcement.
Yeah. So when we assign these, we're partnering with law enforcement, and if law enforcement refers it to the district attorney's office and they file charges, that's when juvenile justice would become involved. So I'm really speaking to who addresses these at investigation, and that is both law enforcement and child welfare, and there's not an age cutoff for child welfare.
Okay. That's helpful clarification. Thank you.
All right, so one of the things we really need to know is a couple of things. What is the what is the incidence of child and child sexual abuse in Oregon? And the data that is currently captured is really based on victim and not initiating child. So I think that's important to keep in mind. So the issue statement here is Oregon law covers child-on-child sexual abuse without explicit provisions for consensual activities between any older teens or between minors that have small age differences. So if you have like a 16 and a 19-year-old, this blurs the line between what is considered a consensual act among older teens and probably more something that's more predatory behavior. Given that the goal of child welfare is to protect the safety of children and promote their well-being, under what circumstances does it actually make sense to allege a minor as a perpetrator of child abuse? That's our issue, right? And the Complex Sexual Behavior Committee right now is really endorsing a direction that emphasizes, I think as Leanne said, assessment, treatment, and services for children who have been impacted and have initiated problematic sexual behaviors. So some of the questions we have that is how are these cases handled by ODHS? And I think Sarah just explained some of that. How many children are actually labeled child abusers now, and what is the breakdown by age of that data? So we're going to look at some data to give us some answers to some of that. Now, this data was provided, shared with us from the Complex Sexual Behavior Committee facilitators, and this information was collected from the CACs. This is a 5-year period, 2018 to 2023, from the Oregon Child Assessment Centers. And they received a total of, during that 5-year time period, 1,692 total referrals where the alleged perpetrator of sexual abuse was another child. This may not be comprehensive. This is it may not include all of those alleged perpetrators. This is what the CACs are reporting. So as you can see, it hovers around 290, 300 over a 5-year period. And these are perpetrators under the age of 18 that have a type of abuse of sexual abuse. Okay, so when we look at children 0 to 18 that were referred to ODHS as alleged perpetrators of child abuse in general, the large percentage you see here, the highest prevalence of abuse is sexual abuse. There's an other, which I'm not quite sure what the other is. There's neglect, physical abuse, witness to domestic violence, and drug endangerment. So those are kind of the categories where you see children 0 to 18 referred as alleged perpetrators, with sexual abuse being the largest.
Does that align, Sarah, with kind of what you would expect there?
It depends.
Again, this is what the CACs have been able to collect. So they may be missing some things, right? Because the system as a whole doesn't track this by perpetrator, tracks it by child victim, obviously.
Okay, so yeah, the numbers could actually be different, I suppose, for what's referred to ODHS, if not everything that gets referred to ODHS is going through the CACs.
Exactly.
Right.
Yeah.
But yeah, it's definitely much higher on sex abuse than any of the others.
Thank you.
All right, so what we see here are children 0 to 18 referred to ODHS as alleged perpetrators of sexual abuse, and the racial demographics of that, what the different colors represent: American Indian, Asian Pacific Islander, biracial, Black, African American, Caucasian, Hispanic, Latino, other unknown, and white. I'm just not sure what the difference is between white and Caucasian. So I don't know if that can be. Sarah, do you know what the difference is there, or why?
This isn't ODHS data, so I do
Right,
not.
right. Okay.
I don't know.
Maybe anybody out there from the CAC world, if, do we have Sarah Stewart out there, or
Samantha, maybe. I don't
Samantha,
know.
maybe? Yeah, I don't think they're
Okay.
available today, but anyway, okay. But clearly, right, seems to be overwhelmingly white here.
Right.
Yeah. All right.
And then these are gender demographics. So the alleged perpetrator of sexual abuse, female versus male. So you could see it's largely male versus female who are perpetrators of sexual abuse. Same set of data, 2018 to 2023.
And here's the age.
And then one more set of data, the children referred as alleged perpetrators by age group. So those that were 0 to 12 are the more of a kind of a rust color and kind of a pinkish, or maybe it's the other way around. I don't know what these colors are, but there was one to the left, the more yellow is 0 to 12, the one to the right is 13 to 17. So as you can see, largely older children are alleged as perpetrators of sexual abuse versus younger children, although there are pretty significant numbers of younger children. As they decrease over time, but there are significant numbers. All right. So I think as Sarah was explaining, and I'll go a little further on this, is the current approach to child-on-child abuse is really a multifaceted exploration of a number of different circumstances that happen at the screening part of ODHS. So at ORCA, they're really looking at gathering additional information to help them make decisions about how this particular referral about child-on-child abuse is going to be handled. So they are looking at age in terms of are they chronologically on target? What's the developmental level of them? What is their physical ability as well as their protective capacity in case they were left in charge of another child or responsible for another child? They're looking at the family circumstances. Did the family know about what was going on? What role did they take as they learned about this? Were they protective? Are they able to protect given the circumstances? What actions did they take to protect? So they're going to be looking at all of that in terms of the caregiver parents. And then they're going to look at the context of how this abuse happened. Was it mutual play? Was there force involved? Was there power and control involved, or any coercion, trickery, anything like that? So that's really important in terms of trying for I think ORCA the screeners to really figure out how they're going to approach dealing with this particular referral. And then also looking at speaking with collaterals and gaining further context from whoever is reporting it, for sure, but gaining further context from schools or from witnesses or daycare, wherever this is happening, to get some context to how frequently is this happening? What other behaviors are they seeing, experiencing, those kind of things. So they're really looking at trying to get a full picture before they even do anything with this at the screening process. And then their options for responding to the incident is really, they can have a sexual abuse allegation against the initiating child and assign it for investigation. But in many instances, they're looking at the protective capacity of the parent, so they would also be assigning maybe a neglect allegation against the parent of the initiating or the impacted child, just depending on what the circumstances were as they gather that information. And then they're also going to be looking at, is the child's behavior so out of the norm for their age and their development that they possibly could be a victim of abuse themselves, and they're acting out as a result of being victimized and traumatized. And so when they feel that that's kind of happening, they assign that child as a victim of abuse with an unknown perpetrator. And so those are kind of the options. I see Sarah said, if 1 to 3 do not apply, it is to close that screening. So that's the fourth option, which is do nothing, right? So you're looking at, what's the parent's role in this? Are the parents protective? Do they have the protective capacity? Are they aware of it? Do they take action right away? Is the sexual abuse against they assign it for sexual abuse against the initiating child, but also looking at whether that child could be a victim, and then if so, assigning it as with unknown perpetrator. All right. So we have some discussion questions that we want to cover. Ask you guys. So we'll go through those right now. I think what's important when we ask ourselves this question is really considering, what is the impact of a child being labeled as a child abuser and experiencing a Child Protective Services investigation and having a criminal history on their record until whenever. So keeping that in mind, under what circumstances should a child be identified as a child abuser? Do we think about, is there an age cutoff where we really think we need to do that? Do we look at severity of abuse? Do we look at the likelihood that this is going to happen again? Has it happened more than once? Those are some of the things we want to consider. And then, as I said, what is the impact of this initiating child being labeled as a child abuser, given that it will create criminal history if they're found to be an abuser, and just going through that investigation experience. So we'd like to hear your thoughts on that today. Are there any circumstances in which we should be labeling a child as a child abuser?
And I think the silence you're hearing is that is a tough one for me to answer, at least. Like, because I'm thinking about the situations that I would consider something like that, and then I also think about, that the implications of that then for the remainder of their life. And whereas in criminal situations, often juvenile records are sealed, would that be the same in a child abuse situation? I guess would be a question. Do we know that? Have other states done that? Have we done any of that looking?
Well, what we have looked at is what other states do in terms of it. If they do have children, many states have an age cutoff. There's a number of states that have age cutoffs for labeling child as abusers. The records are always available, but what many states do is automatic. They have an automatic expungement process if there hasn't been additional abuse since that was founded, or there's a certain period of time has gone by and there hasn't been any additional things, then at some points it's when the minor turns 18. At some points it's when there's a certain period of time has passed, 10 years or more. It varies across the nation in terms of that, but there's in many circumstances there's a process for them, but the record actually always exists.
And so those are typically states that have a formal registry of their founded abuse instances, of which some minors obviously could be in that as perpetrators. But I think we saw Adam's hand up and then Sam. Yeah.
Yeah, and
Adam?
I just want to echo Amber's in the chat. So wouldn't they then be labeled as a sex offender for the rest of their life? That's explicitly and specifically what I was thinking as well. Amber is like, and I believe Tori helped me out, Sam helped me out if I'm wrong here, that kids that have kind of sexual offenses against other children actually have one of the lowest rates of recidivism of any crime type. I believe. Tori, you're kind of.
Well, they're certainly more likely to commit crime in a different category than another sex offense. But I think we're kind of mixing up two different populations. One of kids that are adjudicated, and then I think we're talking about kids not adjudicated through the DHS system. And so, for kids that are adjudicated, most of those crimes, if there isn't a sex abuse crime, those are non-expungible crimes, and so those do stay on their record. However, at the end of supervision, there's a court process, a court hearing, where the court would determine whether or not they have to register. And so just in my experience, you don't have a lot of kids, if they've completed treatment and kind of done what they needed to do, then they don't have to register, although they can never expunge their record from that. So criminal history check would show up. For kids not adjudicated, I think the only way that would show up is if they were applying for something that had to do that registry background check. I think that would be kind of that piece for them. And just kind of my 2 cents about, do we label kids sex offenders or not? I think part of that is around age, and I think part of that is around the type of offense that it is and how much coercion or force would be used with that. So that would be my 2 cents on that.
Okay. Sam.
Yeah, I think it's a really complicated question to come up with a simple answer, because from a criminal standpoint, it really doesn't lend anything. The facts of a case are what's going to be what determines a criminal finding or a jurisdictional finding within the juvenile system.
So-
and
Can I interject for just 1 second? Just because I think we're not going so far as into the criminal code about this, are we, Sylvia? If this rises to the level of a crime that child is adjudicated for, that's out of scope of our purview of this group. We're talking about the records retained about the sexual abuse incident.
Well, it says criminal history on their record is the bottom bullet point. So
okay, so maybe that's an overstatement of record would be probably more accurate in this context.
Well, I think
just their history, right? Like you can still ask under certain circumstances in Oregon for a search of, has this child ever been involved in a founded sex abuse incident? And if under all the caveats that Oregon has right now, or if we decide to recommend a registry, for example, where those are formally placed on a registry and that becomes its own search process, right? Then we're talking about those coming forward, which is equally impactful, I think, right? So I apologize for maybe overstating the word criminal here. Sylvia, would you agree? We're kind of drawing a line in the sand here.
Yes,
Yeah.
yes.
Around sex abuse founded dispositions is all we really have control over speaking to out of this committee.
That's
So when
really
you
dependent on age.
say that again,
Well, it's kind of depend on the age of the child because Oregon doesn't have a minimum age requirement for
correct.
occupancy, right? And so typically, kids under the age of 12 are not charged criminally for offenses, but there's nothing that said they couldn't be. And so I think, being able to have, that's something that we worked on some time ago, a couple of sessions ago, was trying to get something in place around minimum age for filing delinquency petitions, and that didn't pass through the legislature, but there is probably some conversations around that and what should that minimum age be, and it varies across the country between really young, 8 or younger, up to 14. So in Oregon, we had kind of talked around 12. That's similar to where we're at right now. That you have to be 12 years old in order to be committed to the Oregon Youth Authority, and so that was kind of the age that we kind of were talking about. But
and that's on the juvenile justice side, right? You were trying to modify that. Yeah, I got
but
you.
when we talk about this group of kids, I think we should define who. Typically we're talking about kids under the age of 12 that are going to stay in the dependency system and not typically have a delinquency petition filed, even though the behavior could warrant a delinquency petition. So when you say, it's not a crime, it's only because of their age it's not a crime, not because of the behavior. I guess that's what I'm trying to point out.
Yeah, that's a great point. And it may be both things. It may be a combination of an indexed thing like age plus not a completely egregious, offense that's going to impact other kids in the future in a likely way or something. But Anna, you had your hand up.
I was just going to chime in as far as the recidivism rates, generally speaking. So some of the training that we have had here has highlighted specifically around training for problematic sexual behaviors through trauma-focused CBT. They really highlighted that in a general population, so not adjudicated youth, but across the population nationwide, that the recidivism rate was very low, even without treatment, like exceptionally low, and even lower than that with treatment, with the appropriate treatment. But also, there's very, very little access to appropriate treatment in our state.
Exactly.
And then I also just wanted to flag one of the factors around youth who themselves have experienced sexual abuse and then have reactive sexual acting out behaviors, who oftentimes haven't received treatment, and that's just like in the mix there.
Yeah. No, that's a good point, Anna. And I think the other question to consider about that is, will kids that go through the child welfare system for this investigation and founded allegation as a perpetrator of sexual abuse get treatment either?
Well,
that's my big question about this. Like, if you were a victim, maybe in that third option that we showed that Sarah talked about, it's possible that you could maybe, but I don't know the answer to how much case opening is happening on a dependency side for a victim, for a perpetrator.
It's only happening if we have, it's only happening, so a dependency case is only going to take place from the child welfare lens. We're only going to file a petition if we have allegations against the parents. So whether or not children who are the initiators and end up with some sort of founded allegation under the way we currently have to do it, get treatment, depends on A, is that treatment available to them? And B, are the parents willing to engage in that treatment? And if they're not, then C, is it egregious enough, their lack of willingness, that we could have an allegation against them for that? And so it's really complex.
Right.
And it is safe to assume that many of these children do not get treatment just because they ended up having a CPS investigation.
Yeah, that's true. Yeah. Okay. Thank you, Sarah. And then who was next?
Annalise.
Annalise. Yeah.
Okay, I'm going to advocate for kids.
Go for it.
One, it is deeply upsetting and troubling to me that a 12-year-old child could be criminally prosecuted. Number two, it is deeply upsetting that any child could have to carry with them a founded disposition of child abuse against another child for the rest of their life, when it could bar them from possibly teaching, being a CNA. I mean, it would close a lot of doors, certainly being a child care provider. Children do stupid things. Children do not think like adults. Children are impulsive. I mean, developmentally, if you've ever taken child development, and I have at the master's level, so postgraduate level, and I've taken child development up through the age of 21. Why? Because child development recognizes that even the 18-year-old brain is not fully developed, and impulsivity is still an issue. Up until sometime for females, it's like 21, 22. For males, it's like 24, 25. So I'm just gonna say, it's not very woke of Oregon to be going after 12-year-old children or 13-year-old children. That's, to me, is sick and disgusting. I'm just gonna say it.
Mm-hmm.
Children may not understand what they're doing. They need help. The fact that Oregon doesn't help a lot of children, and the fact that the Ways and Means Committee just cut $4.35 million from our most rural communities to be able to get an FTE to do this work when it's related to childcare, to a problem inside of a childcare program, signifies to me that what we really want to do is we just want to cite and shut that kid down. We just cite it, we feel better, we punish the child, and then we feel better. And yes, this really upsets me. Also, a child, 16, even 17, I know 40-year-old people who don't know how to go through due process. They don't know how to do an administrative hearing. They don't know how to advocate for themselves. They don't know how to find a good attorney. They don't know how to find an attorney that does the work. They don't know how to fight. I've worked with personally 2 attorneys who didn't even know how to do an administrative hearing because they were used to trial litigation, not administrative rules and not administrative hearings. So not only do children likely not understand what they are doing, they have not considered the consequences. They haven't premeditated yet. They've carried some sort of retribution or revenge scenario in their head, but they have not thought about the consequences. They certainly have not thought about the consequences to themselves. These children are unhealthy. These children who are coercing others to do things need help. Instead of a label that shuts off their ability to participate in a successful manner with society for the rest of their lives. That is a mark that they should not carry. And you want to find it, then fine. When that child turns 18, boom, that record becomes unsearchable and can never be opened, because no 18-year-old launching into the world, which is a dark and scary place, where there is very, very, very little option for justice unless you can afford to buy it. And what young child or their parent raising a young child can afford it? Well, they're probably living in about 5 communities here in Oregon. That child cannot participate in any sort of self-defense, and certainly will not be able to actively represent themselves in any form of due process. So for children, I will be the voice of children, and I will say that what we do around this issue and around abuse or criminal charges of children in Oregon completely ignores justice for children.
Thank you.
And it's infuriating, it's upsetting. And so my recommendation would be that if we're going to create a cutoff, unless the child is being prosecuted, let the criminal justice system handle it, and we investigate the situation. And if we're not going to label a child at all, the only instead of a finding, what we need to have is services. That's the only thing that needs to be found for that kid is services, supports, and help.
Thank you, Annalise. Adam.
Yeah, I think I'm going to try and kind of pull us back down a little bit on the temperature. I understand your frustration, Annalise. I also just want to say that there are a group of dedicated, caring professionals that every day go to work to support young people who make bad choices and help do restorative justice and support those young people to exit the juvenile justice system into adulthood to be caring and stand-up members of the society. And so I think it's a little bit more complicated than charging a young person who's a juvenile for a crime. So I do want to say that. And we're not here to talk about the juvenile justice and criminal system anyway. As I look at some of these though, and as far as charging children with child abuse, I'm looking at physical abuse and assault of a child or physical injury to a child caused by other than accidental means. I don't know that we need to be looking at, schoolyard fights that are just kind of dumb kid stuff and making them child abusers, right? That doesn't seem there's work to be done there. And if there's, again, weapons involved, et cetera, it's going to go to juvenile justice, right? Same with threat of harm, right? We know bullying's a problem. I don't know that looking at the definition of threat of harm and emotional abuse, you could kind of pull that into a lot of things related to children discussions. So I think I lean away from children being considered as child abusers. My 2 cents.
Thank you, Adam. And Tori?
Yeah, it's just, when we talk about we spend a lot of time talking about the sex offense. I think that's probably the most common one that comes up, but there's a whole work group working on that. And so I don't know that it's really good use of our time to go and dive deep into what should or should not happen with that group. A work group just like ours has been working on that for months and months. And so I think they've got that focused on it. Like Adam's kind of pulling back to, let's maybe look at some of the other categories. And again, when a child is investigated or some incident happens and maybe there is some kind of founded claim or however you want to say that through DHS that something happened, there's really no requirement on parents to get treatment, to do treatment. And so I think that's a different piece of the system that we should be looking at. I think there should be some responsibility on parents to seek out treatment for a child or counseling or something. And if they don't respond, then I think DHS should give them enough to be able to file something. And I know that's not what DHS wants to do. They have plenty of other things to file on, but especially when we talk about the sex offense stuff, those kids don't get treatment and then they turn 12 and do the same behavior that they've been doing, and then they get charged and they're in the criminal justice system. And so I think those early intervention opportunities we should do everything we can to make sure that that takes place. And that includes holding parents accountable for providing the services that they need.
Mhm. And then Brian, I think.
I'll take my hand down there. I think the question I have is what's gained by it, and what's lost if we don't do it any longer. And what I mean by that is this: is that I think if you think about why do we label anyone as a child abuser, I would hope that the primary reason is safety. But I know that part of it is, whether people want to talk about it or not, or admit to it or not, is about punishment. In some people's minds, that's going to be part of that label. But I think that's more targeted at adults. But I would hope that the primary reason that we're labeling anybody is about safety and creating a safety that something's not going to occur to somebody else, or that we're not going to have further abuse. That being said, is that really, when it comes to children, are we seeing that as an effective safety measure by labeling them as an abuser? And is there what would be the alternative if we didn't have that in place? The thing that would be concerning is that if there wasn't full follow up with any given safety situation like that. So if we took away that there was any kind of tracking of that or labeling of that situation, and we have, let's, use the circumstances, somebody that's older, 15, 16-year-old that has committed some acts, and there's no knowledge of it for where it needs to be known about, so that we can try to make sure that there's a safety plan in place. I work in schools. We need to work effectively with people to make sure that we're creating safe environments, because there are situations where a young child even has something that they've done with maybe a sibling or somebody at home, and then it's carried over into something happening at school as well, where there's a repeat of that offense. And some of it comes down to how well things get communicated so that we can create safety plans. So there needs to be thought of how that safety aspect is there. But I don't know that labeling a child is really the pathway to getting to that. And certainly agree with the idea that having something that's going to be a long-term impact on a child's life, because the brain hasn't fully developed all those pieces. But I think that we have to figure out what's the purpose for it. Why is it in place? Now let's make sure that whatever that purpose is, that it truly is a valid purpose. And then if so, how do we implement it in a right way, and in a way that's thoughtful to the age of a student, the developmental stages of life and so forth, and that we're not doing it simply to be punitive, we're not doing it to create harm, and that we're doing it for the right reasons.
Thank you, Brian. Kristen.
Thanks. I think Brian makes some really interesting points, and some that are kind of on my mind too. And Annalise also kind of raised this in her comments. This is obviously an incredibly complex and multifaceted policy issue, but sort of from a legal perspective, aside from everything else that's going on of like, should we investigate, shouldn't we? I have concerns about the due process rights that a child has when they are founded for abuse. I mean, it's essentially a legal process there. When a parent or a caregiver is founded, or even a third party, they receive, some sort of notification about that in the mail. They are provided with sort of, their options for contesting that. When you're providing that to a child, they may not understand that. Some people, adults, unless, for example, a parent or caregiver hired an attorney for a child, counsel gets involved to try and contest these things. There's no right to an attorney for something like this. And given the, potential lifelong consequence and impact of being included included on that registry, that is a concern to me. Especially, given the fact that there's no sort of expungement process that exists for founded dispositions in Oregon. And I see a disparity in the way that children who are perpetrators of abuse are treated, in the context of this administrative finding that lives on the Central Abuse Registry, as opposed to a delinquency case or adjudication or whatever it is that's filed in court. Those records are protected by statute and are very challenging to access, and that same type of protection would not exist. It does not exist for this population. And while there's still some confidentiality protection there, I mean, their name is still going to pop up in a way that it would not with respect to filings in the delinquency side of things. And that it just seems strange to me, and I guess inequitable is kind of the way I was thinking about that. But those are my thoughts from sort of the legal side of things. Child has to be reach the age of majority 18 before they can do a lot of things, and it just doesn't really seem to align that they would be captured on this type of registry. And there may be a reason that they should. I don't, like I said, I don't think that there's an easy answer. Like if we had a 17-year-old that was sexually abusing, for example, a 5-year-old, is that something that we think should be captured? And I don't know the answer to that, but I think it's something to keep in mind.
Thank you, Kristen. Brian.
I just want to kind of go back to something Kristen said, I think, or Kristen, maybe somebody else said this too, is that being out there for people to see about as far as a student, I want to make sure I'm clear on this, is that because I haven't looked at these registries as closely as far as this. We've typically, when we're looking at registries in the school, we're looking for people that are going to be hired. So a student, not a student, but a child, their name will be out there on this, no matter what their age is, where people can see that they're on a registry list. Is that right?
Well, Oregon doesn't have a registry per se.
Not a registry, but
it's just they go search the existing record.
You can search the existing record, and that when you search when you search that existing record, though, you can find the child's name.
I mean, I think, yeah, because the child's name goes in on a request, and then they say, yes, there is an instance here of founded. And I believe they say the type of abuse as well.
I just want to again say how crushing that would be for any student. I had a case a number of years ago when I was working in a different district where there were some students that did something inappropriate, and they typically don't release students' names to the newspapers, but in this case, they released their minors and they released the names to the newspapers. It was crushing to these kiddos, and I'm not saying that the behavior was okay that happened, but it was crushing. It had those types of things can have such an impact of people, self-harm, things like that from that, especially at that age. I think that's one of the things that really has to be considered, is that it is such a high level because your brain isn't fully developed and you're thinking my life is over, and then you react by that thing. So I think we have to be really careful about how that information is out there, because I think they're two different. They're not necessarily they're part of one whole thing, but they are two different things. The manner in which we make that information available and who it's available to is different than saying whether or not there's going to be a record of it. So I think there's a lot of room in there to make decisions that would be protective, and a range of decisions that could be made.
Thank you, Brian. Okay, I think if there aren't any more comments on this, we're going to move on to the next part for For the
But-
sake of time,
I just want to summarize one point here, Sylvia, before we move on. It sounds like what I'm hearing y'all say is this issue of minors as perpetrators really touches on multiple topics, right? In everything from scope of jurisdiction to due process to expungement rules to, you know, standard of proof to clients' rights. I mean, it's almost like we have a minors thread through all of those recommendations that we may make. And because I think that the difference between our committee and the other committee around this topic is that the other committee is really thinking about the intervention pathway for this population. We're thinking about the systemic response to this population. And so I do think there is something we need, we will speak to about this, but I'm hearing you guys loud and clear about the interrelationship of all of these things, right? That we can't just sort of isolate this issue and say, here's a single recommendation about minors that's going to take care of everything. It's sort of like a package of things. Would you all kind of agree with that? That we don't want to make a simplistic recommendation around this. So we will take that into account. Thank you guys so much for this. Okay, so moving right along here, we wanted to kind of bring you in to our process here for how we are pulling together all of this context and information that surrounds the conclusions and findings and recommendations that we've drawn. And we again just picking up on our conversation from the last meeting, we just wanted to start with this notion that we've drawn not only from you all as our expert advisory group to provide input on our final recommendations, but we've also drawn from multiple other sources, right? Everything from interviews with legislators that we've had, outreach to parent groups and focus. Oh, I hope that's the other AI and not ours. Yeah. So we are still.
yeah, it says your note taker's still going.
Okay, great. Thank you. Our MDT partners and staff that came through our survey and other conversations that we've drawn from service partners that we've outreached to, and of course, national best practices that are all informing our final recommendations that's supporting Sylvia and I to develop this output. And so we just want to kind of lead you through from where we started to where we're going to end up with the report. You all remember that, we started off with these series of kind of study topic areas that we wanted to examine, fell into these 4 domains, and we've been exploring these systematically throughout the months. We have our scope of jurisdiction cluster of things around the scope and the shared responsibility, and this issue of child on child abuse kind of starts there, and then a whole host of definitional topics that we've been exploring, from the dual definition issue around child abuse in Oregon, all the way through individual refinements to individual definitions, as well as addressing the issue of naming perpetrators in statute and clarifying this duplicate or sort of double set of terminology for disposition findings that you all have. And then there's a host of things that were kind of clustered under the investigation process around clarifying the standard of proof and looking at alternative pathways at the front end that could be feasible to explore in Oregon more deliberately, as well as maximizing and optimizing your MDT process. And then finally, this whole cluster of due process topics around the appeal process itself and client rights notification and our registry and expungement topics. And so, we've kind of taken this piecemeal approach to some degree, but what we realized is that we needed to put it back together into a storyline, if you will, that sort of matches the systemic environment that you all operate in or need to be operating in order to have a place for the recommendations that we are making. I think this last topic is a great example of that, right? Where it touches various areas of this whole system when you start to explore a single subject or topic area. And so this is our little attempt, right, at sort of trying to envision, sort of a future state, if you will, that would create a home for all of the recommendations that we all have been talking about. We're about to land on here. And it starts with calls to the hotline, right? And this funnel kind of represents the scope of jurisdiction that Oregon now has, and may shift that scope slightly through the output of this report. But more importantly, we're talking about at this very front end, what we're calling the initial safety response, right? That really is pivotal, what happens at screening, right? And we're seeing something emerge as we look at the recommendations that we're making here that provides a slightly different picture here, right? Where you could really have kind of three options here to, assign to investigation, your normal two pathways through CPS and OTIS, but you could also have an enhanced ability to refer to community with a more robust community-based prevention network, right? And again, think about this in the long view, right? Like, this is not a turnkey set of recommendations that can all happen tomorrow, right? There's certain aspects of this picture that would require a longer time frame to implement, to have in place. And so this is sort of the long view that captures everything, right? The visionary look at this. And then this third pathway here is the ability to more deliberately delegate a certain segment of what comes through the front end here to your partners, right? Whether that's law enforcement agencies, and not just cross-reporting, but really prioritizing a certain subset of what now is handled all by ODHS, but could more appropriately be handled through law enforcement, as well as having licensing and oversight agencies be a part of that too. So that brings us into kind of the next phase, which is the investigation process itself, right? Where your dispositions live and taking appropriate action and having your founded or unfounded or unable to determine determinations made. And then of course your due process is, we're putting here, even though it starts here in terms of notifying clients, it's really this back end, what happens after a founded allegation occurs for those in the out months and years to be able to appeal that, or be able to know what's appropriate to have on a registry, or what expungement rules might be necessary to have in place. And then finally, the child abuse definitions sit here as the foundation, really, right? They inform the entire system in many ways. So all of those adaptations that we want to make to the definitions themselves would underpin this whole vision, okay? So you're going to see this graphic a lot throughout the report, utilized in different ways. And the first way we're going to utilize it, right, is we now have bundled all of those topic areas that we just talked about a minute ago in the previous slide into these 4 new structures that live in that last graphic I just showed you, right? So that outer environment of prevention and early intervention that surrounds everything, that's where our alternative pathways. And now these are phrased as short, brief titles with verbs, not an exploratory topic, but a statement that recognizes the ultimate recommendation that we're gonna make here. And then and they're numbered so that you guys can follow along easily in the report and read through the context that leads up to each of these ultimate recommendations, so that you're not just looking at a title here and being asked, well, do you agree with this or oppose it, or can you validate this? It's back to this question of how does this group weigh in a systematic way on all of these elements that are coming into the report in context. And so you can see that our initial safety response section has lots and lots of topics in it, right? Because that's really where we start telling the story and talking about how this changed view would look around, we want to slightly narrow the scope of jurisdiction a bit, right? We want to share responsibility for investigations, and we want to modify some of the child abuse definitions. And then they all specifically live within those subcategories. And then for the investigation process, we want to align the standard of proof. We want to enhance client rights notification. We want to strengthen, MDT and STM practice. And then in due process, we want to make some changes there as well. So now these all live kind of in the context of that vision. And Annalise, I'll take your question in 1 second. I want to just go one more slide and say we now can, place all of those numbered items, right, into the sections where they're talked about in context in the report. So the report structure itself will follow this this vision, if you will. So Annalise, go ahead.
I just want to check in. So under the due process part, because that's
Yeah.
for my local, that's a huge issue.
Uh-huh.
So are we making specific recommendations on how to streamline the
Yes.
appeals process? Okay, I think I missed that meeting. And then we are advocating to establish a child abuse registry.
Yeah. Yes.
Okay, and I think I must have missed this part. I'm maybe I was sick or something. I didn't show up at that meeting. Can you tell me, or can the group tell me a little bit more about why we want to establish a child abuse registry? Like, what's the purpose of that?
You want me to?
Yeah. Go ahead, Sylvia.
The purpose of the registry, right now, what you have is you have a process in which, if there's some folks that, if they want to employ individuals in an environment where they're going to be working with children, they reach out to ODHS to see if there's any previous, founded dispositions or history. They're looking for history. And this process is separated into different entities that keep that information, right? So like a registry would keep all of that information. In different states, they do it different ways. In some states, the Department of Justice holds this registry, and it's limited to only founded allegations, and anybody that is employing a child employing somebody who works with children can then submit a request to do a background on that person. But all of it is contained in one location. It's not contained in separate locations. And then it's limited to those founded dispositions. And then there's an expungement process that goes with it in many instances, or some period of time where some things need to be removed. So it just centralizes that process so that anybody that's employing somebody that is going to work in an environment where children can access that information for a background check. It's not just open to anybody. It's limited to who can actually access that information.
Okay, yeah, because it's not like a publicly available thing.
No.
Like
No,
go
no.
on and use this to post on
No.
Facebook about how horrible this person is. Because,
No.
I mean, I'm already, anything that I would have or any childcare provider would have would be housed in the central background registry, right? So if we have a finding against us, it's in the CBR.
Mm-hmm.
So it's not like I'm not already, but I mean, I just want to make sure that, and then there's the safety portal, which is all over my licensing history. That's publicly facing, and I don't have a problem with that. So it's not that I have ideologically a problem with a child abuse registry. I think that I just hope that the lawmakers, because here's the thing, right? Once you get lawmakers started on something, you lose control of it, right?
Well, that's why, Annalise, we want you to read about the recommendation in context.
Okay.
Right?
Yeah, because I just want to make sure that,
because you're
not...
right. We're all going crazy trying to think back to the conversation we had 4 meetings ago and oh my gosh, I wasn't there and blah, blah, blah. This is our way to encapsulate it all and give you guys an opportunity to take your time, absorb it, read through it. And we're going to show you after the break exactly how we can still weigh in here, right? Over the next 2 to 3 meetings to be able to give us your final your final refinements of that. It's like, yeah, this is great, but I think you should add this to that, or this may have a relationship to this other recommendation, or whatever it is, right? So that we're all kind of looking at this big picture in context and seeing the interrelationship and really saying, yeah, I can, it's a way to build our consensus that isn't so gunshot and piecemeal. And you know what I mean? Like it gives everybody an opportunity. So I appreciate you guys listening to that. And, we will send you out these slides. You'll be seeing this tomorrow in the draft report of the first half of the report. So again, if I'm hoping this picture gives you that sort of touchstone that we can be thinking about how all these things fit together. All right. Other comments or questions? I see something else in the chat here. Oh, that's a pretty I know, it was kind of a brainstorm. You know how you have the aha and the light bulb just goes on, and it's like, child welfare is a systemic flow of a story. We were trying to really take a client through from beginning to end, right? Like what all is being impacted here. So otherwise, we can't represent a logical line of, reflection of what all this incredible body of topics that we've all spent 9 months deliberating about, right? All right. Well, we are looking at, it's 2:20 only. Is there anything else that anybody wants to talk about? We have a little bit of time before we were going to take a break. Any thoughts on any of these last few slides? Okay. Well, if not, I think we'll go ahead and take our break now then. And again, please don't come back at 3. Please come back at 2:30 would be awesome. Or even, how about 2:35? Let's take a 15-minute break. Get yourself a cup of coffee or an iced tea refill and stretch your legs a little bit. And we'll come back at 2:35 in 15 minutes, and we'll move on to talking about our report a little bit more and our validation process that we've designed for you guys to participate in over the remainder of our time together. Okay? So get yourself a break, rejuvenate. We'll see you back here at 2:35. Thanks, everyone. Okay, I think we'll go ahead and get started again. If you all can come on back from your break, and if you can, turn your video on so we know you're back. And we will go ahead and kind of segue from that kind of conceptual picture that we just shared with everyone to just helping you guys kind of get oriented to the structure of the draft report that we're developing right now, and also to walk you through a validation process that we're going to introduce you all to, so that everybody can kind of weigh in on this content that will be put into the report. So first of all, we have an outline for our report. These are sort of the high level sections that will be the subject of our outline for the report. We'll have an executive summary, which isn't written yet. That'll be the very last thing that we write, that we'll be able to take a look at our August meeting, or right before our August meeting. We have a background section right now that just kind of orients folks to how we got here, how this committee was created, all of that. We have a methodology section that really outlines the process that we took to tackle our scope of work, and all the different streams of input that we accessed in order to inform our deliberations and our findings and our recommendations. And then the bulk of the report is really our findings and recommendations in context. Sylvia, I have to give kudos to just her brilliant thinking around this, in terms of, really emphasizing that, the child welfare system, it's a flow. It's a storytelling kind of environment, if you will, to arrive at many of the actions that the system takes, that how partnerships go back and forth, and there's a lot of fluidity to it. And so being able to write that story about what leads up to and what really informs these findings and recommendations, I think is the very context that you all were asking for last time, right? Is to really say, what, not just what is our bottom line recommendation, but what really informs that? What's our rationale for that? How does it relate to other aspects of a well-functioning, effective, healthy system? And so that's the kind of tone that you're going to see throughout the report. And the findings and recommendations section, like I said, is broken out by those four areas that we just saw in that graphic before the break, right? Prevention and early intervention, sort of surrounding environment to the system, the initial safety response, which is all that front end screening and scope of jurisdiction pieces that set the stage for investigations, and then the investigation process itself. And then the due process element as well. And so just as you saw all those individual items that we started to place on our graphical map, you'll see the narrative follow that same flow in the report. We're also going to have a section called implementation considerations. And that's really going to lay out, everything from the kind of staging that might have to happen with the nature of the recommendations that are contained in this report, from some of the, shorter term, if you want, low-hanging fruit in terms of change that may happen on a shorter term basis, and then the more medium term kinds of actions that would be necessary to implement other of the recommendations. And then finally, there's some that are really a long-term change process, actually, right? And will take quite a bit of effort and investment in order to put into place. So that'll be part of the implementation considerations, as well as other information that we want to convey in this report that really sets the stage for any other kinds of agreements or collaborations or partnerships or training or support or funding or other investments or leadership development or anything that really needs to surround these recommendations to make them successful. And then finally, we'll have a conclusion and an appendix, which will have some of our more, detailed materials that support the recommendations. But most importantly, that's where a summary of the output from our validation process that we're going to describe to you in a minute can be contained in the report as well from all of you. Okay. So that's our outline. In terms of, how this process is going to kind of unfold on our timeline with, sure, oh, there we go. Over the, we've only got these 3 months left, right, to wrap up our work with all of you. And so here we are in June at our June meeting, and starting tomorrow through next week at this time, or about a week later, we're going to get you the first half of the report and give you a window of time to respond to that report. So give you a chance to read it and use this validation form that I'm going to walk you through in a minute to give your feedback on that first half of the report. And I'll show you in a minute what we mean by the first half. Okay. And then at our July meeting, and in July, we'll be able to, in the meantime, in between meetings, Sylvia and I will be continuing to write the second half of the report, right, which we're already starting to put together now. But that'll be complete so that after our July meeting on the 10th of July, the day after, you'll be able to receive that second half of the report. And do the same kind of validation process with that content as well. And at this meeting in July 2, we want to start to dive into some of the implementation considerations and help you participate and raise those with us about the first half of the report, right? Some of the recommendations that are in the prevention, early intervention, and initial safety response areas of our recommendations so that we can, tap your wisdom as well as what we're thinking about in terms of what are some of those things to consider as a state, as policymakers, as, implementers of these recommendations should they proceed. And then in August, so as you're then reviewing that second half of the report between the meeting and getting that back to us through our feedback loop, we'll be incorporating that information, and then we'll have the final report available to just any final tweaks that you have in August, anything we want to still debate a little bit or talk through or refine any further. We can have our August meeting, which will be, as you know, our final meeting, because we'd love to get any final input from all of you by August 21st, so that we have a few days to polish everything up and to have that, because we really need to be able to submit this to our internal sponsors by the end of August. So that gives us time. We'll have our meeting on the 13th, and following that, you'll have time to give any final input, and then we'll be able to wrap that up and get that down the road. And hopefully we'll have time for a little celebration there as well at that virtual meeting for all the hard work that y'all have done. Any questions or anything about the timeline or how we're going to kind of do this in 2 parts here? Okay, nothing in chat. All right. Oh, I see something. I just, okay. That's Sam leaving early, no problem. All right, so let me then just remind everybody of what you'll be reviewing, okay? This little 3-column list here is what you saw earlier, just organized by kind of first half and second half with these other parts of the report included. And so when we talk about the first half of the report, what you'll be receiving is the background and methodology sections in draft form, followed by the findings and recommendations section, just for the prevention, early intervention, and the initial safety response sections, okay, which is a lot. It's actually more than half of our task items that are all going to be contained in this first half. But by half, we mean, you know, of the 4 sort of categories in our report under the findings, you're getting 2 of them out of the 4 in the first half. The prevention and early intervention, which only includes 1 recommendation in that section and a lot of context and narrative to lead up to that recommendation, and then several recommendations that speak to the initial safety response area of the system, narrowing the scope of jurisdiction, sharing responsibility for investigations, and modifying the child abuse definitions, and all of these detailed recommendations within those categories. Okay. And so that's what you'll get starting tomorrow. And then the second half you'll get right after our July meeting, and that will contain the investigation set of recommendations and the due process set of recommendations, as well as a draft of the implementation considerations for all of it, right? And a preliminary conclusion as well. And we'll just probably give you a list of the things that are in the appendix and have those, you know, available on the hub or something if you want to look at them in detail. Okay. So what we wanted to do as well is kind of show you how this validation process is going to work. So we didn't want to just have you read the report and then just email us back with your comments, right? Because we really wanted to be deliberate about each individual recommendation and give you all, because remember we went back and forth about why are y'all called voting members if you never get to deliberately weigh in on each of these things. So this is our opportunity then to do that. I'm going to literally show you how it works in a moment, give you a little demo of how it's going to work, because we're going to use a Google form to capture your input. But where we're going to have that material, we're going to have both the draft report and the validation tool itself on our communications hub site, where we've been putting all our minutes and our agendas all this time. And we'll also send you an email tomorrow, obviously, with a cover instructions and the links back to those materials. And then again, you'll have a full week, including the weekend, to review that first half and give us your input. And let me show you what I mean by input. Okay. I'm going to switch views here off of the slides, and I'm now in our Google form. That this is the same kind of technology we used for the survey that went to the, you know, all the MDT partners and the staff and everybody. So I think this will be a very accessible method for us to both get you guys focused on the things we really want your validation on, and gives us an automated way, if you will, on the back end to nicely be able to pull all that together in a big spreadsheet of what everybody has said. So this is what it'll look like when you click on the link to the validation form. It'll say HB 4086, JAC report, first half input, right? And we've got a little, you know, just description here of what we're doing. There's a link right here to the form, which I'll show you at the end, where that takes you right to the hub, so you can get to the report. And right there, if you haven't already downloaded it or something onto your desktop. And so our vision of this is that when you get that, say, 30+ page report or whatever it ends up being, that you'll read it through, right, from beginning to end, this first half, right, so that you get the full context of everything. And then the way we structured this form is after you've read that first half, you come in here, you go ahead and put your email in here just so we can, know who's been able to respond and who's not yet responded. That's just for us to know. And then it'll go through each section. We even have an opportunity for the background and the methodology section. We'll have a reference of what page numbers of the report you'll find that on. And you just have an open-ended place to put, if you find anything in there that just looks weird or typo or anything that we've missed, or you should also talk about this or whatever, feel free to put that in, right? This is not a required field because it's not one of our recommendations, but we welcome, right, your eyes on the report. So you can type anything in here that you want to. And then you'll go on and do the same thing with the methodology section. It's add this here, blah, 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 whatever you want to say, right? And then we get into the findings and recommendations section of the report. And again, this is going to cover quite a few pages here, right? And there's an overview section to it. Again, if there's anything you want to put in here about that part, you can. But now we're into the first recommendation. So these follows the same numbering scheme that we just went through in the slides, right? So bring alternative pathways to scale in Oregon, right? That's basically the recommendation in that first prevention and early intervention area. This is 3 pages worth of content that are associated with this. Here's the key part I want you guys to pay attention to, right? We created an input process here where you have some choices in how you want to characterize your reaction or your validation of that particular recommendation. You have 3 ways you can answer. One is accept as is. You like it just fine. It's great as it is. You basically would agree with that recommendation, right? If you click on that, you'll just go right to the next recommendation. Okay, so let's just assume that you love this idea of the alternative pathways. You say accept as is, you hit the next button here. And this will now take you immediately to the next section because there was only one recommendation in that other section. And we're starting in on our initial safety response section, right? And the first one category, we have a whole category around narrowing the scope of jurisdiction, right? And the first one is 2A, reduce the span of third-party other slightly, right? Okay, we're not throwing out all the third-party others, but you'll read about all that in that section, right? That's on these pages. So let's say you're thinking about this, you kind of like it, but there's a few things you'd like to add to it or you have concerns about. Let's say you say accept with conditions on this one. And if you do that, when you hit the next button, you're still on this same item, reduce span of third-party other, and you've said accept with conditions. And now we want you to just give us a little bit more information. Right? Please give us specific details about the conditions or changes you feel are needed to accept this recommendation. And you can go to town here and just type up a storm right here about what do you think this needs? Is there some, you have a concern about it? You have an idea? If we tighten it up this way, it would really work better, whatever, right? It could also be something like you forgot to include this corroborating data that would really make the case for this thing, whatever, right? You could say something like that as well. Okay. And so after you've completed that, then you go on, right, to your next item, right? And just to show you the third option on this one, this is naming perpetrators in statute is the recommendation short title. Here's the pages in the report where you can see the context about it that you've already read, hopefully. Let's say you hate this idea. You have a whole other idea. You never liked this from the beginning. What you can oppose, right? But here's what we'll ask. When you choose oppose, you'll go to the next slide. You're still on name perpetrators in statute. You've indicated you oppose it. We now have 2 questions for you to answer. Please describe why you oppose this recommendation, right? Just tell us what's your objection and describe what about it you disagree with. And then secondly, please describe an alternative recommendation that would be acceptable to you. And that can be anything from don't do anything, keep the status quo, suggest an alternate solution, whatever you want to do, but describe it here. Describe the alternative here, right? In your own words, what you think that is. And that's it. We'll go through all of the items of the first half one by one in this fashion, and you can put your ideas about this throughout, right? You can also go back and change your mind about something before you submit it, right? You can also save this and go back to it. You don't have to finish it all in one sitting. And so that's how we're going to capture your input. And then on the back end, we're going to be able to see all of this in a big spreadsheet of what everybody said. So we'll be able to include in the report, 79% of the Jurisdiction Advisory Committee agreed with this recommendation, right? But as we're going through this, right, that's ultimately what we'll be able to say at the end. As we're going through this, what this is really going to do is make our product be better, right? Because some of those conditions that you mentioned or considerations that you'd like to see addressed, those might be great ideas to improve and tweak and make that adjustment as we put out the second final version of it after we receive your review comments, right? And there'll be a certain point where we'll just have to say, this is the state of the JAC's reaction to this body of work. So remember, as we talked about last time, this is a report that the legislation asks the facilitators to produce with the advice of the JAC. So we felt like this was the most deliberate way that we could get your advice documented at the point in time when our recommendations are most fully expressed and you have the best information to weigh in about it toward this, latter part of our work together. Okay. So questions, comments, reactions? How many of you think this helps address some of the things that we talked about last meeting in terms of having a deliberate way to weigh in? Seeing some stuff in chat here. Annalise is looking forward to working on it. Thank you. How about others? Others have reflections. And can you see yourself getting through this in the next week or so? And again, we'd love to give you guys, 3 weeks to deliberate on all this, but our calendar just doesn't allow it. So, please let us know if, hey, I'm getting through it. I've gotten to this point. I need a couple more days, whatever, right? We're out here by email, but if you can stick to that schedule, that'll really help us a lot to stay on course. Adam, did you have a comment?
Yeah. I see saving disabled up there. I'm just like, I know that I may not be able to sit down and just get through this all the way in one run.
Yes, no, I totally get that. I'm going to double check that with our technical support on this because I'd really like you guys to be able to save it and go back to it if you can, right? Otherwise, if for some reason we can't do that, then you know how this form works. And what I would do is be like making some notes to yourself in the sidebar when you're reading through the document and then come in here and do it all in one fell swoop. But I will get back to you with the instructions tomorrow about how that's going to work. Okay. So you'll know ahead of time. But thank you. I know as I said that, I saw that little thing on there too, Adam, and I thought, ooh, I have to talk to my techie folks and make sure we get this set up right. Who else had a question or comment? Anybody else? Was it Anna? No, it was somebody. I think a couple of people that were talking last time about how are we going to weigh in on this? Can you just give me a summary of it right now? And I'm hoping that addresses that problem. I don't think it was you, Anna. I think it was somebody else last meeting, but I just remember, you guys are very conscientious about these things and for good reason, right? And so I think with this narrative surrounding the recommendations and pulling kind of what we've learned over the months together on this, it's really going to help you feel like you're making a much more deliberate input to the process as a member, as a member of the group. And if Judge Love, are you out there? I don't know if she had to go. She might have had to go.
I'm here. I'm here.
Oh, good. I mean, if you have the time, I would love you or one of your staff. I mean, if you want to weigh in on this too, I know you're not supposed to be a voting member.
I know
but
that was going to be my question. If I'm not a voting member, I think
we know you're not, and so we wouldn't count you in
Okay.
the percentages.
Mhm.
We would love your comment.
Yeah, we can do the comments definitely, just as long as we have that line, so I'm not crossing it.
Yes, that sounds great. Does everybody else feel comfortable with that? Our one non-voting member just won't be in the percentage count, but we don't want to exclude Judge Love's expertise certainly from this process. Okay. Excellent. All right. Other thoughts, questions, comments? I was going to just go back to let me just clear the form. Because I did want to just go here for a second, just so y'all could see. This is in our hub. We're going to have a new section now. That's our scope of jurisdiction study report, and we haven't quite. We'll get this all figured out by tomorrow. But this is where the report itself will be, and this validation form you can access through here as well as through the link in your email. So if you lose sight of everything, you can always come back to the hub and get access to both these things. Okay.
Like there was a question in the chat, Leslie.
Oh, sure. Yeah.
From Lisa Joy. How much time do you estimate we set aside for the task?
Yeah. Okay. So for reading the report, I'm going to put that in the email tomorrow because I'm going to be doing that activity in the next 24 hours is reading through the entire thing, right? And saying, okay, about how long does it take to read through this thing? And so we'll estimate that. And then I'm going to assume that you have access fairly immediately to your expertise about these various things. So then we'll also judge about how long it might take to fill in, let's see, what are we looking at here? As we look at I just want to go back for a second. So you have a total of, there's 4 domains, if you will, of recommendation that you're going to be answering, but it's a total of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. It's 12 distinct recommendations. that you're doing that oppose, accept as is, except with reservations or conditions choice on. Okay. And, you may want, it's also possible that you could say, that you want to see what's going to happen in the second half for some things first, or you can have a tentative vote here on something, because you can go back and change your mind when you see the second half too about some of this stuff, right? Like the child on child thing that we just talked about that kind of touches on many different things, right? That's something that once you see how it's handled in due process or how it's handled in investigation, you might go back, and that's fine. We're not going to do the tally on all this until August, right? Of where did everybody finally land on this? Okay. But if you can get through all 12 of these by reading it through once, feeling pretty confident about your opinion, and then when you get the second half, you'll have a revised version of the first half with that. And and we'll give you a little summary of here's what we basically tweaked based on your input in the first round. You're welcome to go back and vote again, right? On one of the earlier ones, as well as you'll have these 7 things to weigh in on as well. These 7 recommendations in the second half. So we definitely front loaded it, as you can tell, because so many of these things are interrelated, right? But we didn't want to wait all the way till the full report and give you one giant time and then we only had one meeting to talk to you about any of it. You know what I mean? So that's why we're doing it in 2 halves. Does that make sense? Yeah. Okay. Any other comments, thoughts, brainstorms, concerns? Sylvia, what did I forget? Anything else we want to hear? What's in the chat here?
Covered it all.
Oh, super helpful. Yay. Thanks, Lisa Joy. It's always nice to hear when we're in our little echo chamber and Sylvia and I think it's a brilliant idea. Then it lands like a lead balloon, but I'm glad you guys think this might work, right? Who wants to put a thumbs up in their little window if they think this will work? I see a few. Yay. Thanks. Thanks, Lindsay. Thanks, Brian. Thanks, Annalise, Scott, Alexis. That looks like a majority. Yay. I'm assuming the rest of you were on the phone. And you'll tell us later how you think it's going. Okay. So we will proceed with this. We're going to have a busy 24 hours because we're going to try to fit the child on child thing in here. But if it turns out that we have more thinking to do about that than we can fit, we may just pop it into the second half. Okay. We'll just say skip that one for now. If it's somehow not there, you'll know that was us and not you guys. Okay. And it'll be included in the second half. So we're just right up to the wire here, and we don't want to sacrifice all this other content for us continuing to noodle about that. Okay. So yeah, so you'll get it tomorrow. You'll get it back to us by the 19th. Sylvia, I'm going to let you continue to talk about just kind of next steps from here so for the next times that we meet.
All right. Next slide. We're just going to recap for you guys the between meeting work. So we'll be sending the draft to you by the end of the day tomorrow with the link to the validation form that you will have. We want you to review the first half of the report draft and submit your input on the Google form by Thursday, the 19th of June. If you could get it to us by the 19th of June, that would be great. We're going to be reviewing all of the feedback and incorporating improvements, corrections, clarifications, and even important to remember that all of the information that you provide to us, all of the feedback, will be summarized in the appendix of the report. So we will be including that in a summary to ensure that all of the feedback is incorporated.
Yeah, thank you for mentioning that, Sylvia. And by that, I mean more than just the percentage of, what did we get for acceptance and opposition and considerations, but we want to summarize like what was that opposition about. So it's almost like a minority little summary at the end, if there is that, right, for any of this by section or something, right? So that way you guys will be represented in the report, as well as the audience who reads this report ultimately knowing that, this was the facilitator's conclusion about it with the advice of the JAC.
And then our goals for the next meeting, just to recap, to present the complete report draft for your review and input. The focus for that second half review is really on that second half of the report draft. But as Leslie Ann said, you will be able to make additional changes to the first half of the report if you so choose to do so, based on any reservations you had about your response because you didn't have the second half of it. We understand that that might happen. So you'll have the entire report to review, and we'll do that at the meeting. That would be July, that's the
9th.
July 9th meeting. And so your feedback would be due on the 17th of July, which is a week after that, after we'll release that second half of the report the day after the meeting on the 10th. Our next meeting, we really want to focus on discussing implementation considerations for the first half of the report. So as you're reading through and making your comments on the first half of the report, if you have things that you think are really important need to be in place before any of that starts, or thoughts about implementation considerations, try to jot those down as you're going through the form and keep track of those, so that when we meet next month in July, you'll have those ready to talk about when we ask for them, because we really want to make sure that we're getting your input on what any implementation considerations should be for that first half of the report. And then we'll be confirming our goals for the final advisory committee meeting to be held August 13th. Those are goals for the July 9th meeting. Any questions, concerns, anything else you want to add, you want us to think about, provide at this time? If you're having any issues along the way when you're trying to do the feedback form, please just email us and let us know. We'll address those. You never know when there could be glitches. It's all electronic, so of course there could be problems. Please just email us right away and let us know.
And I think everybody was totally fine to access this platform in your environments. I think Samantha was the only one in her hospital setting that had some restrictions. So we will get this format to her separately, and she'll just give us her input in a flat file, and we'll just include it into the tool. So it'll be part of the picture here. But I don't think anybody else has that problem, right? You don't have environments that like don't allow you to touch anything else but your internal approved applications or anything like that, right? Because I know we've used this before for a lot of the homework assignments and things. Yeah. But I know we have some new people too. All right. And again, I know some people were saying that their schedules are tough over the summer and they may have to miss some of these meetings, whatever. That's the other reason we designed this in such a way that you don't have to be here to be able to get this substantive ability to weigh in. And so for those people that aren't here today, we're going to get the recording up right away and obviously send these instructions right away, but we will invite anybody who falls into that category who hasn't had the benefit of listening to this today and they're now receiving something in their inbox the next day, to reach out to us and we can certainly walk them through. I'm happy to do that to help people get oriented, point them to the part of the presentation here that they can view and understand it and all of that. So that way we can get all of our members on board pretty much at the same time. All right. Okay, well, this is a first, you guys. Usually we are fighting the clock at 4 o'clock to try to squeeze everything in. But you know what this does for us? It gives us more writing time. So we're happy to peel off 45 minutes early. Does anyone object to us adjourning a bit early today? Is there anything burning on anyone's mind that we need to talk about before we close today? Y'all could use 45 minutes too. I bet. All right. Well, thank you guys so much for all of your input and great attention here today. And we will look forward to getting that report in your hands, close of business tomorrow as well. All right. Thanks, everyone. Have a great
Thank you.
afternoon. Take care.